on the record. It is September 26, 2024, at 10:30 a.m., and this is a public deliberation of the Baltimore County Board of Appeals in case number CBA 24033 regarding Seminary Falls Partnership LLC and the Bedford property on Seminary Avenue. We are deliberating a motion to dismiss. The first thing I think to dispose of would be Mr. McCann's offer of protestants, Exhibit 6, the email. I don't think it should be admitted. I don't know if you feel differently.
I agree, Madam Chair. It shouldn't be admitted.
I agree as well.
Okay, so that takes care of that issue. The second issue that was argued that I think is easy to dispose of is whether the director letter is dispositive of vesting and should have been appealed. And, you know, I happen to think that's a real stretch and that the director should not be making legal conclusions. And it's not a letter that was available readily to the public anyway. So I don't think we give that any weight myself.
I agree.
Yes, I agree as well. Thank you.
Okay. So Mr. McCann argues that the plat should not have been recorded, the zoning change should control. How do you feel about that? Who goes first?
I'll just say a few things, unless you want to go first, Mr. Lauer.
No, please go ahead. Thank
Okay.
you.
You know, I agree with much of what Mr. McCann argues as far as how the statute works and the effects of the statute. So I think it does create a sort of absurd race to the courthouse situation where the administrative law judge approves the development plan, but then there's this sort of period in between the approval and an appeal where if the developer had the forethought to file a plat before the ALJ even made their decision, then maybe they can get an approval of the plat recorded before there's even an appeal. And I think that's kind of an absurd result. You know, I think that if the section F or part F of section 32.4229 was to make any sense, I think it would cut off the whole end bit, which is if the case involved an unresolved comment or condition, and then you could say, all right, anyone can preserve a 30-day period where they can appeal it and no one could file a plat, and that would make perfect sense to me. But that's obviously not what it says And I think it's I think it's impossible to make 100% sense of what that section in particular says. I think any interpretation is going to be fraught in some way or the other. So I mean, I think that I'm in the position of agreeing with Mr. McCann's sort of parade of horribles, but also I don't know that there's anything we can do about it. I think that there is this period of time where if the plat's recorded in between the ALJ's decision and taking an appeal, then that's the way it goes. And I think, equally absurd is that you can downzone the thing while there's still a development plan pending. So, I mean, I guess two wrongs don't make a right, but my opinion and a quarter will get you a cup of coffee when it comes to how I think it's supposed to work, rather than
We're
how.
gonna get a cup of coffee for a quarter.
Yeah.
Ah,
So the way I think it ought to work and the way it probably does work are two different things, and we have to go with the way I think it does work. And well, not I, but we. And that's my opinion. Is
And the way it works is,
it's an absurd result, but I think once the plat is recorded, the plat is recorded. I don't know that we can undo that, even if we wanted to.
Mr. Lauer,
I agree and see the dilemma that we all have here. I I mean, the language is clear in terms of the recording, I think, that it can be recorded. I don't see there's a prohibition within that 30-day period of time. I don't see a
I
prohibition.
don't see it either. I agree with you.
So that's
So the plat is recorded. It's not appealable. Do we still have, even if we dismiss the motion, the plat records 2 lots. Do we have jurisdiction to then consider the development plan, since what the plat vests? And if you don't have it, it's Exhibit C to protestant's motion to dismiss. Well, what it vests is different than the development plan.
I mean, we have not heard arguments about the effect of that, and I certainly don't know what the effect of that would be. I mean, to some extent, maybe that creates an issue that the Protestants can raise in some other way. But I don't think it's been raised here.
Oh, I think Mr. McCann raised the 2-lot issue.
Okay.
And I think Mr. Mudd's contention was it vests the zoning in effect on the property to be the RC5, not the RC5 and RC7. And if you follow that logically through, then the developer could pursue the development plan and then subsequently file an amended plat.
Yes, that seems to me to be the logical way that the developer would proceed if in fact we would approve or uphold basically the ALJ's decision, right?
So on that basis, are we saying we would deny the motion to dismiss and proceed to hear the case on the merits now?
yes, that would be my thought.
I think that's the only possible conclusion.
And then what we will do is deny the motion and get counsel back to see if they are prepared to proceed on the merits.
Madam Chair, Ms. Stopkin,
It's a scheduling issue.
okay,
I-
we've had, the merits case have been before us in the arguments that were given. I don't understand,
Is
not
there,
clear on
well,
what you would ask us to do at this
then
point.
there's nothing, you're saying there's nothing further to be heard.
Not that I see. I mean, perhaps there is something further to be heard. I'm not seeing it, Madam Chair, but please tell me.
Mr.
Help me.
Stelmack, I'm not disagreeing with you. I'm just trying to sort out where we are.
I mean, my recollection is we already heard the arguments in the main case, and the parties have submitted their memorandums, and we were set to have a hearing on that when this superseding issue came in. So we postponed that, and I think it was announced for today. I mean, I don't think we can have a public deliberation without an announcement, but I think that it was announced for today.
Well, too many papers. I have the announcement. The announcement says, notice of argument on motion to dismiss and deliberation immediately following.
So there, in the announcement, it doesn't say that we're gonna decide the
No,
merits.
it also, we would also be deciding the merits of the case. Because we had scheduled that deliberation when the motion, you're correct, Fred. We had scheduled that one. So then let's go on to the merits.
Well, there were 4 points, I believe, that Mr. McCann raised. And I think he mentioned them also this morning, related to traffic, open space, the tree, and the view shed. I think those were the 4 that
I
had
agree.
jotted down.
I agree. Those are the ones I have noted as well.
Okay. The question I think becomes, did the ALJ deal with this below, and is there any reason for us to change that or do something, modify or whatever that opinion? And I don't find it, Madam Chair. I think the ALJ considered all of these matters from what I can see. Be open to hearing any other board members' thoughts on that, of course.
Mr. Stelmack?
No, I agree with Mr. Lauer. I think that the ALJ's opinion covers all the bases. I don't think there's any evidence that we could overturn the ALJ's opinion.
I also agree, though I do think this whole discussion of the adequacy of the roads where they are state roads is misplaced. And I'd like to have some discussion about that, because it strikes me that where you are dealing with Falls Road and Seminary Avenue and Valley Road, they are all roads controlled by the state. and to take a position that the county adequate facilities regulations control those roads strikes me as an impossibility, because if the intention of the adequate facilities bill is to make sure capital improvements are identified and scheduled and funded, it is beyond the county's authority or ability to do that on any state road. And I find it very frustrating that this issue comes up before us. I distinguish it from sewer lines, which the county not only has the ability, it has the duty to correct. And I just wanted to put that out to hear your opinions, because it's a recurring issue before us. We've had a number of cases where these intersections are involved and they're all state roads. I don't know about what other intersections there are. There are only a few in the county. But I just think that you can't make a decision based on the inadequacy of a state road, particularly one out that could not be improved by the county under any circumstances. You have any thoughts?
No, I agree with you completely. I've seen it in another matter, and I agree completely, Madam Chair. I mean,
Mr. Stelmack, any thoughts?
I think this is only my second case that involves roads. So certainly defer to your greater experience. And if that's something that you'd like to include in the opinion, I would certainly take that into consideration.
Well, I'd like to put it in the opinion so that it can get litigated, if for no other reason, because it takes a higher authority than us to make a dispositive decision, and maybe get the state and the county to get in sync about the way they measure traffic and how to resolve these issues. It's not serving the public in any way this way. If our ultimate goal is to improve the conditions, which is what the public facilities law is supposed to be doing, and not as anyway, let's leave it at that. So if you don't object, I would like to at least include that in whatever decision order is written.
I don't object at all, Madam Chair.
Not at all, no.
Okay, so here we are. We are denying the motion to dismiss and affirming the ALJ decision based on her reasoning and findings, which were very thorough. And with that, I'm going to conclude this deliberation. And thank you for all your time and thoughtful discussion.